afternoon. Rich Tyson here. Hey, today we're going to do something I'm calling Rich Insights, wherein I love to talk with those who have great expertise in a given area, things that add to the dimensions that we can bring at CEO Builder. And today I'm with Warren Pate of Pate Peterson, PLLC, law firm that works primarily with patents. And so I have a few questions for Warren and look forward to getting his insights on these topics. So the first one has to do with inventors who often, I think, work with you, Warren. Mm-hmm. The question is that I think you receive often is, can I patent my invention? Give us some feedback there.
Sure. So that's a question that we get a lot. Oftentimes there's a certain excitement when somebody kind of has an idea or a new vision of how a particular problem can be solved. They're excited about that. They've heard of patents. I think in general our society is very pro-patent. We like inventors. Mm-hmm. That's a positive thing. And so people are often very motivated to look and get something patented. So they go, well, can I patent this?
Yes.
And so oftentimes the first thing when somebody asks me that question is I kind of rephrase it. And the reason I do that is because fundamentally a patent does not create value, it protects value. And so what that means is that if you want to use a patent and have it be an effective thing, you have to build a business. Mm-hmm. And then the patent can help protect that business success. But if you just get a patent without ever building the business, what are you protecting? There's nothing to protect. So when somebody asks me, can I patent it? What I try to do is reframe it and say, do you want to be in this business? And if they do, and they are interested in building a business, then the patent can make sense. And then we start looking at what steps make sense to kind of start moving in that direction. In general, it makes sense to kind of keep those expenditures low at first as you're testing out new concepts on the business side.
So a patent fits somewhere in the process, but looking at the patent as the be-all, end-all, this now has created a business, we get the cart ahead of the horse.
Yes. Yep. And the idea, I think we sometimes think, well, if I get it patented, I've kind of made it. Mm-hmm. That's kind of the government stamp of approval.
Yes.
That I have a legitimate idea, I'm a legitimate entrepreneur, I'll be successful. And so what I say is, no, let's back that down. Even if you get a patent, if you haven't built a successful business, what is the patent protecting? So you have to build that business, and then if you build a successful business, yes, absolutely, those patents come into play and it can be very important, mm-hmm. depending on what you're trying to do in your overall strategy. Mm-hmm. But mm-hmm. you have to build that successful business first. And so everything that I do as I counsel clients is looking at the business. Does it make sense for the business? Mm-hmm. And is it moving the business where it needs to be, rather than just, can I get a patent?
Very good.
And so it's a different mindset. It's really becoming more. It's more consulting. It's more talking business stuff and making the patent system work for the business owner, rather than the other way around, where it's like making the patent or making the business owner contort to fit the patent system, which is serving which, and the different emphasis can make a big difference in the outcome.
Very good. Very good. Yeah, I think for us philosophically, as we look at strategic planning, we have an intuitive sense that a patent couldn't be very important. But what I'm hearing again is it's a piece of the process. It isn't that if I've got a patent, now I'm in business, now I've made it, and the government's protected me. And as we've talked sometimes a little bit about the idea of a value proposition with a customer, a patent could be part of that, certainly, but often the value proposition will have nothing to do with protecting intellectual property per se through a patent or otherwise. Is that correct?
That's right. There's lots of different ways that market success can be generated. Mm-hmm. Oftentimes, if it is a product mm-hmm. or in a particular thing that is easily copied in the marketplace, patents play a very important role.
Sure.
If it's more of a service-oriented business, their success may be on their culture, how they interact with their customers and the experience that they create. Mm-hmm. In that case, patents are going to not play a big role or at all in that. And so different industries.
And it could be a mix of the two
right.
as well.
Right.
Yeah. I know as we've chatted intellectual property certainly covers more than patents. Talk to us a little bit about trademarks.
Sure. So a trademark is a way of designating the source of goods. It's a way of, it can be a symbol. You could picture that Nike swoosh.
Yes.
It could be the words Nike. It could be different things like that. Stylization. So there's lots of different things that we can use, symbols that we use. And so they become very important as a vehicle or a container to hold the goodwill of a company.
Sure.
So that people see that and they immediately think of that business, what it represents, and it brings that all to mind. So they become a very important thing. And so
Can you have a trademark without registering it?
you can, and there are certain rights that you can start collecting in what they call common law rights. Now, and a lot of people, depending if what they view their business goals are, oftentimes if they're just saying, well, this is just kind of my business, this is what I've done, they'll have a trademark, but they won't necessarily seek to federally register it. And so, whether or not to register it becomes a question that I answer a lot. And,
Yes.
and obviously, I'm a big proponent of that. I think that there's a lot of advantages to that sometimes people don't necessarily see.
Yeah, tell us more about those advantages.
So, one thing I think people think is, well, if I get a registration, then I can sue somebody, and that's true. You have certain rights that you can assert, but they look at that and say, well, I don't really want to do that, and I'm just operating just fine as my trademark as I am, so I'm not motivated to that. But I tend to see it as a different value proposition, and one is, so what happens when you file a trademark application, an application for registration with the U.S. Patent and Trademark Office, is that trademark application goes and becomes indexed, part of the database, right?
Sure.
And so anybody, whether it's a patent attorney or an applicant, somebody that's trying to test out new marks or something like that, can go there and they can search it.
Yes.
And they will see your application. They'll see your proposed trademark, or
Right.
if it's already registered, they'll
Right.
see it. And so what that does is, then they have to make a decision and say that, well, this guy's already out here in this space. Do I want to go there when I see that they're already there? And so it becomes kind of a deterrent. And that happens at multiple levels. It happens with a trademark attorney. For example, if somebody comes to me and has me do a search, I'm going to go take a look, see what I can find. If I find something that I think is close to what they want to do,
Yes.
I'll go back and tell them, I say, well, I don't think that's a great choice of a trademark for you, because you're just kind of walking into their space, and that's
Right.
going to create problems for you down the line. And so I actually become an advocate for that person whose filing is there at the U.S. Patent and Trademark Office, because I'm trying to dissuade my client from walking into a legal problem with them.
Okay.
And so that's me with my clients. But picture it, you with your application. That means there's hundreds, thousands, tens of thousands of trademark attorneys out there who are counseling their clients with respect to your mark. If the mark that they're searching is related and hits kind of on your.
So by virtue of the fact that it's registered, they're going to see it, and effectively we got a whole team of attorneys protecting us?
Exactly. And so they're going to be dissuading their clients from picking that mark that might be confusingly similar, and things like that. And so that's all passive enforcement.
Yes.
That is happening, that you don't have to pay extra for, that you don't have to think about, that you're not monitoring on your own. It's happening, and people see what you've done. It's out there, it's in that public database, and they are dissuaded from getting involved just by finding it there. I mentioned trademark attorneys. Another one are the trademark examiners inside the U.S. Patent and Trademark Office. They do searches. And so if somebody does file an application and they think it's confusingly similar to yours, they'll deny it. And so they are policing and enforcing your rights. And so there's a lot of work that is happening behind the scenes that's not just you having to go and sue somebody. And you tap into all that value by filing an application for registration. And given the relative costs to do that, I think it's a great value. And so
So what would typically an entrepreneur pay for something with a logo, a trademark?
Sure. It depends on various factors, how many goods that they're trying to protect, and that they're in different classes. There's different government fees for each one of those. But a number to just keep in mind might be on the order of $1,000 to $1,500 to get an application on file, and that would probably include some searching beforehand. It would include the attorney time, and then probably some and the government fees that might go with it. So somewhere in that range.
And in filing for a trademark registration, we might find that, hey, we bumped up against somebody else's trademark as well.
Exactly. And if that's the case, then you can kind of pivot. It depends where you're at in the process. You know, if obviously if this is a mark that you've been using forever, it might be a different situation. But if it's somebody that's trying to pick a new mark and you initially do that search, you find something out there that's going to be problematic. Well, now you still have time to tweak it, to change, to readjust, and maybe pick something else that might be a better long-term vehicle for your goodwill and for your business.
Okay, very good. Well, one more question for you in the time we have here. Often we work with entrepreneurs who kind of, they have their day job and they do something on the side. Often those who design new products or you know, anything in kind of the design realm. You and I chatted a little bit about the fact that there's probably a few mines in the minefield for them. There's a few steps that maybe because we work with the entrepreneurial side of this, we're overlooking. Could you tell us a little bit about that?
Sure. Usually when there's businesses that this is what they do, they kind of formalize their processes. And so they take people down a particular, they know the road, they follow the same steps, they have the documents in place that they need to make that happen. Oftentimes though, when you're getting to smaller companies or companies that might be working with, say, a student, a designer, or just somebody that's freelancing, or maybe it's the freelancer. You know, it can go both ways.
Yeah.
But oftentimes, the one thing that they miss are getting the contracts in place and addressing ownership issues, confidentiality issues, and things like that.
Right.
And I'll give you an example. So, say, for example, there's a designer, and a company has an idea. They know kind of what they want, but they just need to make it, give that polished look, and create engineering drawings and things like that.
Sure.
So they may go and work with a student or a freelance designer.
Right.
And when that person starts working, they are inventing from a design perspective. And so because of that, they start acquiring inventor rights. So even though they weren't the ones that originated or created the idea in the first place, they're refining it, they're tweaking it, they're saying, let's do this, let's do that. Well, that's all invention, particularly from the design perspective. And as the inventors, they become owners of patent rights or invention rights, I'll say.
Right.
And so that they're the default owners. And so what you need is some sort of a contract to disrupt that default and make it happen and the ownership move as the parties want it to. So for example, if there's a company that's coming in, working with a freelance designer, working with a student designer, then they can present a contract to that designer and say, here's the contract, we're going to bind you to terms of confidentiality,
Right.
which is, you know, common for those kinds of things.
Sure.
And then also say, and you hereby transfer all ownership rights in any of the inventions or anything that arises out of this work over to us. And it's not trying to sneak that into a contract or surprise anybody. It's just saying, no, bring it up front and make it obvious for everybody that this is the way this deal is structured, and that we'll pay you, but we're going to own
Yes.
all the invention rights.
Okay, so there's compensation and there's ownership, and this clarifies what happens there.
Exactly, because most of the time what happens, particularly with these smaller companies that haven't done this a lot, they're just, oh, yeah, you want to design that? Great, we'll pay you this, and they get it. They don't deal with those inventorship issues. And then later on down the line, all of a sudden they're looking at it and say, well, who is the inventor? Well, it's this person. Well, have they assigned their inventor rights to you? Well, we didn't talk about that, and then it becomes more complicated to go back and try to correct that. Oftentimes, they may have moved, they may have moved on, their motivations for being involved maybe are different. They can see things differently. And so anyway, just establishing that relationship with a contract that makes that all clear up front is just a common, it avoids common problems, I guess is what I'll say.
Yes. Well, thank you, Warren. We appreciate the opportunity to work with Warren and other experts on areas that, while we know a lot about what we know, there's things we don't know. And especially in the legal realm, it's important that we understand a lot of these things. And so I think there's several nuggets in today's interview that will be worthwhile to those who view it. And again, we would ask you to subscribe to CEO Builder channel and to give us your comments. You may have some questions for Warren, and I think he'd be willing to field those.
We'll try to.
So thank you for your time today, and Warren, thank you.
My pleasure.